Welcome to the Family Court. You are here today for a protection from abuse hearing, also known as a PFA. In a PFA petition, a person alleges that an intimate partner or family member has abused them or their child. Abuse is defined by the PFA statute. A PFA is not a criminal case. If there is a criminal charge from the same incident, it will not be handled today. The people in the court case are called parties. The person who filed the petition is the petitioner, and the person the petition is filed against is the respondent. Sometimes a person is both a petitioner and a respondent because each party has filed a petition against the other. Now that a petition has been filed, the next step in the PFA process is to have a case review. At the case review, a family court mediator will meet with each party separately to see if an agreement can be reached without having to go to trial. The mediator will go back and forth between the parties to see if they are able to reach an agreement on the conditions of the PFA order. If the PFA case is not resolved during the case review, the parties will have a trial. Everyone has a right to a trial, but a trial is not the only option. There are other options available, and family court mediators, judges, and commissioners can explain your options, but they cannot tell you what is best for you. Your options are different depending on who is here today. If only one party is here, there are three options: continuance, default, and dismissal. Continuance. If the party who is absent was not given notice to be here, the case will be rescheduled for another day. This is called a continuance because the case is not resolved today, but is being continued to another day. Default. If the petitioner is here, but the respondent is absent and proper notice was given to the respondent, then the petitioner can ask for a default PFA order. There will be a hearing with the commissioner who will decide whether to issue the default order. A PFA order that issues by default is the same in every way as an order that issues after a full contested hearing. Dismissal. If the respondent is here but the petitioner is absent and notice was given to the petition will be dismissed. This means the PFA case is over and there will be no PFA order. Any temporary ex parte PFA order will end. If both parties are here, four things can happen: consent, continuance, dismissal, and trial. Consent. If both parties are represented by attorneys, the attorneys will have the opportunity to engage in a brief discussion to determine if an agreement can be reached on conditions or relief requested through the PFA order. The attorneys will be provided a worksheet to record any resulting agreement. If either party is not represented by an attorney, the case review will then be facilitated by a family court mediator. The mediator will talk to each party separately to determine whether parties can reach an agreement. The mediator may go back and forth between the parties a few times to give both parties the opportunity to reach an agreement. If the parties reach an agreement, whether through attorneys or the family court mediator, they will go before a commissioner. The commissioner will review the conditions to be sure that both parties understand and are in agreement. This consent order is then signed and copies are provided to both parties. With a consent order, the respondent is not admitting to abuse. He or she is simply agreeing to certain things, such as to stay away from the petitioner, temporary possession of a house or car, or contact with the party's children. A consent order cannot be used in any other court case to prove that the respondent committed abuse. However, a consent order is enforced in all the same ways as an order entered after a trial. Continuance. If you will not be ready to have a trial on the date that is provided to you by the mediator, be sure to let the mediator know. You'll be given a form to request a continuance, and there must be a good reason for your continuance request. The commissioner will decide whether to continue the case. If the case is continued, you will be given a new date. The commissioner will also decide if any ex parte PFA order should be extended. Stipulation of dismissal. If both parties are here, but the petitioner no longer wants a PFA order, both parties may agree to a stipulation of dismissal. Before the court accepts the stipulation, the petitioner will have the opportunity to talk to an advocate to make sure that they understand their options. A dismissal ends the case without a trial or a PFA order. Trial. If there is no consent, no continuance, or stipulation to dismiss, then there will be a trial. At a trial, the petitioner will try to prove that the respondent abused him or her or their children. The respondent can present evidence that he or she did not abuse anyone. If the commissioner decides that it is more likely than not that the respondent abused the petitioner or the petitioner's child, the commissioner will issue a PFA order. The commissioner will decide what will be in the order and how long it will last. The PFA order may or may not include all the terms that the petitioner had requested. If the commissioner decides that the petitioner did not prove that the respondent committed abuse, the commissioner will dismiss the petition. Any temporary ex parte PFA order will end. A special note on firearms. In most cases, it is a crime under state and/or federal law for a person against whom a PFA order has issued to possess firearms, deadly weapons, or ammunition for the duration of the order. Now you will proceed with the case review. The family court mediator will let you know if the other party is present.